Good evening, everyone. Welcome to the Libertas Chambers webinar with the title Silence, Joint Enterprise and the Legal Trap. Most of you will know me. I'm Felicity Gerry, Queen's Counsel, a member of Libertas Chambers, but I'm delighted to welcome this evening two of our expert speakers, Dr. Susie Hulley and Dr. Tara Young. Susie Hulley is a Senior Research Associate at the Institute of Criminology in the University of Cambridge. She's on the advisory board for the Prison Reform Trust's Building Futures programme. She's worked on a range of research studies, including a study on the experiences of prisoners serving very long sentences from a young age. Dr. Tara Young is a senior lecturer in the School of Social Policy, Sociology and Social Research at Kent University. And the central focus of her research is on marginalised young people as perpetrators and victims of antisocial behaviour and violent crime. This particular webinar is going to focus on their recently published research into silence in the criminal justice system and how young people face a precarious trap as their silence is interpreted as guilt by the police, propelling them towards charge. I think it's really interesting just to think about where Section 34 of the Criminal Justice and Public Order Act came from, which was in 1994, a year after the Macpherson report that spoke about institutional racism. So we get to have a think about whether or not those two things have been tackled and if they've been tackled in an appropriate way. So considering disproportionality in the system as well as silence in the criminal justice system. So hopefully, if the system works, Susie is going to go first. Thank you, Susie, and welcome.
Thank you.
The format, just so that everyone knows, is that Susie will speak first for about 20 minutes, then Tara, then I'll tell some stories, as always, in our webinars that are hopefully relevant to what we've heard from our speakers. And then there will be an opportunity for Q&A. We've got an hour. We always tend to go over, which is fine, but we look forward to your questions. If you want to put your questions in the chat function as we go along, I can come to them at the end. And a reminder that this session is being recorded and a version of it will be available on our website later on. So hopefully, Susie, we can share your slides now. We've had a little practice and it's been a bit slow this evening, so just sit tight, everyone. I'm sure it will appear, but for some reason it was a little slow in the practice run.
Yeah.
Thanks, Tara. So I have a slight technical issue that I can't see myself, which is a little bit off-putting at these things, even though in lots of ways I prefer that. And so if I start to drop low in the camera, just give me a shout. And Tara's going to move my slides on for me. So thanks, Tara. So
just hang on, Susie, for a second,
no problem.
because it's got to load. All right.
Yeah,
no
it's
problem.
clear to me now. I can see.
Yeah.
Oh, great stuff. Okay.
The title slide. So
all right, okay, let's see how we go.
Right.
When you're ready,
yeah.
Dr.
Okay.
Susie Hulley, thank you.
Thank you very much. And thanks for inviting us, Felicity. We're really pleased to be here and really excited to talk through this research. Like you said, it's pretty newly published, so it's always nice to kind of get some feedback and see how it's being received. So I'm going to start by talking about silence, joint enterprise and the legal trap. Tara, if you don't mind moving on, thank you. So this paper is based on a paper that we published earlier this year in Criminology and Criminal Justice. It's based on research that Tara and I carried out, in which we interviewed police detectives, prosecution and defence lawyers, young people in the community, and young people who were in prison for serious violence in which secondary liability was used at their trial. If you can move on, please, Tara, thank you. So newspaper headlines like this, the murder hunt's wall of silence, illustrate an internationally recognised problem, that police investigations into serious violence are thwarted by what has become known as the wall of silence. So this is the refusal of individuals en masse to speak to the police. And explanations for the wall of silence have tended to be rooted in cultural narratives. So a sort of no snitching culture, but also concerns about distrust in the police. Thanks, Tara. So distrust in the police has been blamed on negative experiences of the police, and often similar experiences amongst their friends and their family and other people in their community. And so this includes things like police harassment, the overuse of force. As stated in by a respondent in a study by Rosenfeld et al., mistreatment deters you from wanting to do any type of business with the police. And for Black and ethnic minority people in particular, research suggests that non-engagement with the police is the result of multiple personal and vicarious experiences of discriminatory practice by the police, and which generate distrust. And this is something that Tara will touch on later on. A no snitching culture has been blamed for thwarting engagement with the police because the code of the streets emphasizes that people settle disputes between each other. So they don't go to the police to talk about these problems. And it's said that these this culture is reinforced by violence and by the risk of social marginalization for those who do speak to the police. And there is some contradictory evidence in the US about whether these concerns are perception driven, so whether the actual threats are likely to really happen. But there's also evidence of examples of drug informants being assaulted, raped, and murdered. And certainly, as Rosenfeld et al. Conclude, few labels are more stigmatizing and more enduring than that of the snitch. And so based on these explanations for silence, which have dominated discussions in this area, attempts to increase engagement with the police have focused on improving trust by emphasizing procedural justice. So that's the way the police talk to people, how fair they are in the processes that they use, and also reducing the risk of witnesses who provide evidence in a criminal case being identified. And alongside this type of work, there's greater engagement, to encourage greater engagement with the police. Law reform has attempted to disincentivize silence among suspects. Thanks, Tara, if we can move on. So prior to 1994, the right to silence meant that judges could remark on a suspect remaining mute in police interviews, but they were not able to explicitly invite juries to draw inferences of guilt from that silence. And research around this time in the 80s and the 90s highlighted that only a minority of suspects were entirely uncooperative during police investigations, and most answered questions or made statements either to admit or to deny the accusations that were being made against them. For those who remained silent in interviews, the strongest predictor was the legal advice that they received, with other factors like the severity of the offence and their previous criminal conviction also coming into play. And many of those who remained silent in police interviews went on to plead guilty and were convicted. So this demonstrates that the right to silence did not prevent the gathering of information or the conviction of suspects. However, there were concerns that professional criminals were exploiting their right to silence and impeding the effectiveness and the kind of efficiency of police investigations, how quickly they could move on with their evidence. And this led to changes in the law. Thanks, Tara. So Section 34 of the Criminal Justice and Public Order Act 1994 allows inferences of guilt to be drawn if a suspect remains silent when questioned by the police prior to them being charged, but then relies on a relevant fact in court that they could have been reasonably expected to mention during questioning. So possible inferences might be that information subsequently given to the court was invented, or that it would not stand up to police questioning. So the reform of the law increased the legal risks of remaining silent in police interviews because it amplified the chance of receiving a guilty verdict. And this was despite concerns that were raised by the Royal Commission on Criminal Justice that such changes would be against the interests of justice, because they placed additional pressure on vulnerable people, on vulnerable suspects to engage in the police interrogations, including those who were ignorant about the law. There was a recognition that there were a whole host of reasons why innocent people might remain silent. That might be to protect their loved ones, because they were confused, because they felt shame and humiliation. because they wanted to have a full opportunity to consider the allegations that were being made against them. And so it's the legal risks that we're going to turn to now. Thanks, Tara. So the existing literature on silence has the least to say about the legal risks of talking, although there's some research on snitching that kind of gives us some indication of some of these concerns. So for example, Rosenfeld et al.'s study of 20 active offenders, they found that some feared that they would shift from complainants to suspects by talking themselves into a hole, being caught lying, and drawing attention to their own misdeeds in their conversations with the police. So this was highlighted in the Royal Commission on Criminal Justice, that there was a potential to incriminate oneself was considerable for people who were unfamiliar with legal definitions and police procedures. And this is supported to some extent by Martin Innes's work, who he observed the police work, detectives' work, and he found that the police, a direct quote from him is that the police managed the interview interaction in such a way as to gradually persuade the suspect to reveal more and more information. In the process of doing so, the suspect is perhaps, without realizing it, further incriminating themselves. And research also indicates that there are additional racialized concerns about the legal risks of police encounters. And again, this is something that Tara will come on to. Thanks, Tara. So against this backdrop, I'm going to present the findings of our study, which I'll briefly outline in a minute. But we want to argue that in our research, although cultural narratives of distrust and no snitching explain the reasons why young victims and witnesses choose not to engage with the police. For young people who had experienced as suspected secondary parties to serious violence, they most commonly reported that it was actually the legal risks of talking that persuaded them to remain silent. Secondary liability poses a significant risk to young people on the periphery of violence who are asked to engage in police interviews, particularly in homicide cases, because it can result in a murder conviction and a life sentence with potentially decades in prison. And we argue that it's these legal risks that persuade them to remain silent. Because of this, they then become ensnared in a kind of legal trap, because this silence is then used by the police to infer guilt, and that this then propels them towards being charged with the principal offence. Thanks, Tara. So the study, which started at the end of 2016, examined youth violence in the context of the legal doctrine of joint enterprise in England and Wales as it was then. So semi-structured interviews were undertaken with these 4 groups in the table. And this summarises some of their demographic details. So we interviewed 19 police officers, 90%, most of them were white, and their average age was about 43. We interviewed 22 lawyers, prosecution and defence lawyers. They were around the same average age, and most were white. We interviewed 56 young people who had various experiences of violence. These were young people in the community. Some had no experience, some had been witnesses, some had been victims, and some had been suspects of serious violence. And then we also interviewed 36 prisoners who had been convicted of serious violence when they were 25 years old or younger, and they had been convicted of either murder, manslaughter, or GBH. And it's worth saying, in terms of the prisoners, obviously most would have been convicted before the change in the law to secondary liability and joint enterprise. Thanks, Tara. So in the context of witnessing serious violence or being the victim of it, young participants reported that they refused to engage with the police due to kind of cultural narratives that dominate the literature. So specifically distrust of the police and the concerns about snitching and the physical retaliation or social ostracization that might result in. And I'm going to go through this part quite quickly because I want to come on to talk about the silence of suspects mainly. So if you're interested in this part, please feel free to ask questions or take a look at the paper because there's a bit more on it in there. But just to summarize, most commonly feelings of distrust towards the police were generated by negative personal interactions, as the literature already tells us. So many young people had experienced a multitude of accumulated negative interactions, often first occurring in childhood, and those around them had also had similar experiences. And these feelings were especially likely among young Black and minority ethnic young people who reported experiences of racism and police discrimination. And alongside this, feelings of distrust, many young people refused to engage with police due to their views on snitching, which they said was shared and well understood by their peers. So they told us that the penalty for snitching was most often stigmatization. So young people were concerned that they'd be banished from their social groups, even from their family. The physical risks of snitching were less common, but perceived to be brutal for the informant, and potentially for their families as well. The young people repeatedly stated, snitches get stitches. And so in this quote here, Naomi graphically recollects the threats that she received from the men who she witnessed murder a friend of hers. So she said, they were going to kill me, they'll beat me up, they'll come to my house. It was unclear to the extent to which these kind of threats were realized in practice and people were actually physically hurt. But even in its absence, the violent capabilities of the person was enough to generate sufficient fear to silence the young person. And so while the risks of ostracization and physical violence deterred young victims and witnesses from engaging with the police, for those who were drawn into police investigations as suspects on the periphery of violent incident, they described their silence as being primarily driven by their concerns about the legal risks of talking. Thanks, Tara. So talking in police interviews was considered precarious for young people who were drawn into investigations through secondary liability for two reasons. First, because of the low threshold at which the behaviour is interpreted as evidence of complicity. And secondly, because of the disproportionate and severe consequences of being found guilty as a secondary party, particularly for murder. So as Ian says, he says, I said nothing because I felt if I say anything, that even the smallest part under joint enterprise is paramount to admitting murder. It probably hinders investigations because other people don't want to admit things. Because admitting anything, even involvement, can end up getting you a murder conviction. And supplementary findings from our study suggest that Ian's concerns were warranted because police and prosecution lawyers talked to us about justifying charges for individuals for serious violence, sometimes based on relatively weak notions of intent to encourage and assist, such as association between parties. And again, this is something that Tara will touch on. Thank you, Tara. So for many suspects, silence was maintained because of their ignorance of the law on secondary parties specifically, as well as their kind of ignorance of broader legal concepts like intention, those that were kind of central to their prosecution. And this lack of knowledge led to concerns that they'd be tripped up in interviews or that they'd talk themselves into a hole. And this was exacerbated by their vulnerabilities that were related to their age and for some mental health issues. So almost all young interviewees that we talked to were not professional criminals. In fact, many lacked experience of the criminal justice system, and particularly in the context of serious violent cases. And this directly influenced their decisions to remain silent in police interviews. So this quote here from Raj highlights the multiple vulnerabilities many young people suffer and the impact of these on their decision to remain silent. So he says, I've never experienced a murder trial. I've never experienced an attempted murder trial. I've never been in a situation like that before. I was mentally not there. Physically, I was suffering from anxiety, depression of being on the case like that. I was scared in case I slip up and say the wrong thing, or I do something wrong, which makes me look like I've done something. And these risks were highlighted by those who did speak. So Rosie, who we talked to, who described naively opening up to the police about personal matters, and these contributed to her being convicted of murder as a secondary party, despite, she was convicted of manslaughter, despite initially being arrested for perverting the course of justice. So she says, the police kind of smile at you, they comfort you, and they say it's going to be okay. They ask you such personal things, and then you open up about these things, and maybe you've never even told anyone, and things like that, just so that they can sit there and go, do you know what? Actually, I think she did this, or she did that, and it's really, really heartbreaking. And in another paper, we've described how there are particular risks for young women implicated as secondary parties. Thanks, Tara. So young people's inexperience of the criminal justice system and its processes was in stark contrast to the experience of police detectives who had been trained in interviewing tactics and strategies. As Trevor explains, one of the detectives we interviewed said, the Metropolitan Police Service invest a great deal of time, effort and money in training interviewers. So by the end of your interview, I would exhaust your account to the point where you're down on yourself. And I would almost be pushing you to say, why did you run? Don't tell me you're scared. You had nothing to do with it. And prisoners described feeling pressurized to talk in interviews, being ground down, having their sleep restricted by the lights being kept on in custody, and feeling intimidated, which by things like emphasizing the risks of not talking. As Kevin says here, the police gave me a choice. You can either talk and probably walk, or don't talk and get put in a joint enterprise charge. And despite being kind of terrified this kind of ultimatum, young people remained worried that the police were in a stronger position to frame the narrative of the incident if they did talk, because of their skills and expertise. So this often encouraged young people to still remain silent. And again, this was reinforced by underlying feelings of distrust, and for young Black men in particular, vulnerability in the face of police power, which again, Tara will speak to later. Thanks, Tara. And young people's lack of understanding of the law, their vulnerabilities, their relative powerlessness, and their deeply embedded distrust or fear of the police led them to place unwavering trust in their legal representatives. So in homicide cases in particular, young people reported that their defence lawyers' instructions were almost exclusively to stay silent and go no comment. So Lloyd describes, he says, I wouldn't have spoken to the police because my legals, his legal representatives, told me to go no comment. And you follow your legals, you put all your trust in them. That's basically God to you at that time. You know what you're facing and you realise, hold on, I've come to jail and the starting sentence for gun crime is actually 30 years. I'm thinking, I've been around for 18 years. That feels like a long, long time. What the hell? 30 years? I've never even lived 30 years. I don't know what 30 years is like. And defence lawyers who participated in the study said the same, that in cases of murder, their advice to young clients was almost always to stay silent. Based on the potential implications of their clients talking, the power imbalance between their client and the police, and the emotional pressure of police interviews. And this was particularly so when the stakes were the highest and with young people who were especially vulnerable. Offering a no comment interview made strategic sense when in the prosecution process, and lawyers considered that it was preferable to have an adverse inference drawn from silence than being proved to be a lie in a taped interview, even if the lie was an innocent one. Although they did recognise that silence could have adverse implications, including being used as evidence of gang involvement. Thanks, Tara. However, silence did put young people at risk of being charged. So the following assumption was widespread among detectives who participated in the study. So Trevor says, anyone who speaks in a suspect interview is normally telling the truth and they've got nothing to do with that murder. Very rarely do we have people involved admitting it, or if they're involved as a secondary party on the outskirts telling us what happened. So detectives assessed that young people who refused to speak in a suspect interview were knowledgeable about the offence and often implicated in it. While there's very little empirical support for their conclusions, we just don't know, they appeared to be rooted in a theory of rational thinking that if I'd done nothing wrong and I was arrested for murder, I would be screaming it from the rooftops, which is what Trevor said. So detectives' assessments of what constituted a kind of rational choice in these circumstances were embedded in normative white male understandings of rationality. So they used sort of cultural explanations to make sense of silence among young Black men in particular. But there was also an assumption at the individual level that young suspects were being rational, that they knew what they were doing when they were remaining silent. But this ignores the structural inequalities related to race and gender and the vulnerabilities that many young people reported in our study, linked to their youth, their ignorance of the law, the inexperience of the criminal justice system, and their feelings of powerlessness. Thanks, Tara. And in this way, silence kept young people in the frame and was ultimately instrumental in decisions whether to charge them with serious violent offences, including murder. So police detectives experienced suspect silence as deeply frustrating, and they sort of implored young people to speak in interviews, stating that engaging would prevent young people from being charged. So Adrian, the detective in this quote, says, if he, talking about one of the defendants, if he said in interview, this is what happened, yes, I'm part of this group, yes, I have beef with this kid, and we've all run over to him because we've seen him, and then when I'm there, 3 of them pulled out knives, and I just stood there and kind of almost froze and let it go, then I wouldn't expect them to be charged with murder because I don't think they're guilty of murder. But despite this argument, when we pressed detectives, they recognised that talking could lead a suspect to implicating themselves. So on to the next slide, please. So Louise says, sometimes I think, do you know what? That person would have been better off just giving an account, because the likelihood is that if that person turned around and said, do you know what? I've been bloody stupid. I carried around a gun for someone. His name was Matt, you know, and one of us in the interview say, but doesn't that implicate them? And she says, yes, it does. But you've got things like helping the police. You've got an early guilty plea, which reduces your sentence. You've got age. You've got previous criminal history factors. You'll get a lower sentence. Yes, they'd still get a murder charge. So here, Louise highlights the potential reduction in sentence that a secondary party could receive if they talked in an interview, but she ignores the significant impact on a person of receiving a murder conviction and the extraordinarily long tariffs handed down for murder with a gun, which start at 30 years for somebody who's 18 or over. And so such life-shattering outcomes make the prospect of talking really risky for a young person. Thanks, Tara. And so just to finish, we've presented an analysis that crucially draws attention to the previously neglected impact of legal risks of talking that persuade young suspects drawn in as secondary parties to serious violence to remain silent. It also takes account of structural inequalities that they face in their multiple vulnerabilities, including age, ignorance of the law, and their relative powerlessness. Silence, like speech, is open to misinterpretation, and in the context of suspect interviews, the police hear silence as guilt, and this propels young people towards being recommended for charge. So in this way, young people's silence is weaponized by the police to use against them. And this weaponization of silence is fueled by kind of institutionally and legally permitted association between silence and guilt. And this is embedded in detectives' normative, so they're sort of situated, gendered, and racialized understandings of what constitutes rational behavior in police interviews. Secondary liability and the low threshold at which young people can be considered culpable for a violent offence committed by another is central to suspect silence in investigations, and as we've heard, central to them being charged. Thanks, Tara. So we hope these findings will refocus the discussion on the wall of silence in two ways. First, by encouraging a distinction between silence and victims and witnesses, and the silence of suspects implicated as secondary parties in investigations into serious violence. And second, by encouraging further discussion of the role that the criminal justice system, its law and its agents play in generating silence of secondary parties. And it's on this last point that I want to make three further points. So first, we urge police and prosecution lawyers to recognise their part in enabling or discouraging individuals to engage in criminal cases. This involves taking very seriously the threshold at which people are considered to have assisted and encouraged, and considering whether it's appropriate to draw them in as a suspect in the first place. Second, we call for a return to the pre-1994 rules on the right to silence, whereby judges were able to remark on silence of suspects, but they could not explicitly invite juries to infer guilt from them. Even better would be to recognise the many reasons that people, especially young people, remain silent, and challenge the notion of what's kind of rational at what is likely to be a very stressful time. It's notable that the research presented here suggests that, contrary to its aims, the current adverse inference rule doesn't seem to encourage suspects in cases of multi-handed violence to engage in police interviews. Rather, just as the Royal Commission on Criminal Justice feared, we believe that in joint enterprise cases, in particular, it leads to the increased criminalisation of young people who are on the periphery of violence, and therefore the law is against the interests of justice. And third, we call for reform on the law of secondary liability and its application in practice to remove the low threshold at which an individual can be charged with serious violent offence, and murder in particular. So instead, we propose that those who are present at a violent altercation could be offered an alternative lesser charge specific to the role that they played in that incident, or that if necessary, an offence which appropriately labels assistance and encouragement is used, which offers, again, then a proportionate punishment in response to their involvement. However, these changes we propose, we hope, would reduce currently excessive legal risks that young people face as secondary parties, improve the perceived legitimacy of the criminal justice system, and may even encourage greater participation in police investigations. Thank you very much.
Thank you, Susie. I dropped in and out for a moment, but I realised you kept going, so that's very good. I may have happened to one or two other people as well, but thank you for keeping going with the technology and for fascinating insight into your study and the effects of the criminal justice system on silence. Really interesting stuff. So we'll keep going. If anyone wants to put any questions in the chat, we'll come to that at our Q&A at the end. But our next speaker is Dr. Tara Young, who I introduced to you at the outset of this evening's webinar. And I think she's going to share with us some more slides so that we can hear from her. And then just a reminder, after she has presented her academic research, I'll give you some recent stories about some recent cases where these issues have been live issues in murder trials in England and Wales.
I'm hoping that you should be able to see my screen.
I can. It's not a single slide yet, but I can see your screen. And it is now a single slide.
Now?
Yes, yes.
Okay,
well
great.
done, thank you.
Yeah, brilliant. Okay, thanks, Susie.
I'm just going to say this, if for those of you who are not speaking, I'm just wondering if we're losing a bit of bandwidth. If you don't mind turning your videos off, that might just help us with the bandwidth. And when you ask a question later on, obviously do put it back on again. I hate to sound so dictatorial, but I'm just wondering, because there's so many of you here, which is fantastic, whether we're just stretching the system a little. Okay, thanks, Tara. Go ahead.
Okay, thanks, Susie. I suppose in many ways I have the heady task of marrying findings from another publication that Susie and I have written on joint enterprise, and it's this paper here. And this paper focused on the context of policing murder and how detectives in London explained the disproportional representation of minoritised young people, that is principally Black and dual heritage mixed race young men, in joint enterprise cases. And here I invite you to join me in reflecting on whether there's a relationship between the two. And as a starting point, I'd like to sort of draw attention to the theory of silence that Hallsworth and Young created in 2008. If we contend, as Hallsworth and Young did in 2008, that silence is created through human interaction with several parties involved in its construction, then this paper might be able to tell us something about how detectives in the MPS focus their ultimate concerns, getting their job done, and that is the arrest and prosecution of young wrongdoers and obtaining justice for victims, how these ultimate concerns and the concerns that they have about doing a good job contributes to the construction of the silence they face in criminal cases where joint enterprise is applied. So, by drawing on, or should I say reflecting on, the testimonies of murder detectives, I hope to demonstrate how the construction of risk and dangerousness present in officers' reflections on the rising levels of serious violent crime in London involving young people, and their understanding of the cultural context in which it manifests contributes to the silence that they experience from witnesses and suspects that they encounter when engaging in the investigation of serious violent crime. And in this consideration, I will talk about the potential racialization of the investigative context and how this can contribute to the silence that suspects and witnesses do. Now, I will also consider how these reflections, the reflections that the detectives do, may contribute to the disproportionate number of Black and mixed race young men convicted for joint enterprise murder. So before doing all of that, I think we need to consider as our starting point the structural and cultural context in which the detectives say they're operating in. So on the screen here, you can see some figures, some national and local figures on a serious violent crime that were emerged at the time that we was doing the field work for this study, which was between 2017 and 2019. So I'm not going to go through all of the figures on the screen, but just to point out that what we can see from these figures is that violent crime had increased or was increasing. The incidences of knife crime were increasing significantly, and that they were somewhere near 20% higher than previous years, 2016. Not only that, that homicide was at its highest level since 2008, and that the detection rates for murder had fallen. So this was a kind of the structural context, the context in which detectives were investigating serious violent crime. Now, at the same time, as a rise in violence and a fall in detection rates, there was a broader political policy of austerity. And this was implemented by the government of the day, the Conservative government. And according to Her Majesty's Inspector of Constabulary, or HMIC for short, this was having a serious negative impact upon the police service. Indeed, it was having an impact on the ability of police in general, but detectives in particular, being able to do the good job of investigating serious violent crime. And so at the time of rising rates of violence, the police more generally and detectives in particular were facing ever more internal scrutiny and internal calls for clear up of serious violence. They were facing ever more public and political pressure to do something about the levels of violence and the potential risk to the public. And indeed, in 2019, the then Home Secretary Sajid Javid implored the police in an article published by the Daily Telegraph to crack down on the infectious disease that was knife crime. So that's the kind of structural context. So within that context, we have a sort of a cultural understanding of why these rates of violence are increasing so dramatically. And it's fair to say that the inflation in the violence statistics was reportedly due to the increasing presence of gangs in Britain and the ever-growing foothold that these groups had in their engagement in the illegal drug economy, in rising cases of knife and gun crime, in rising cases of interpersonal violence, including violence against girls and young women, also their involvement in child coercion and exploitation. And what we see in the political domain is a narrative of the gangs as being at the heart of violence, as David Cameron said in 2011, that these groups sit at the nub or the crux of the street violence issue, and it's these groups that are incredibly violent and driving the rates of violence upwards, and that these groups were blighting the lives of residents on the estates of which they lived, and that were responsible for the gang-on-gang murders that we were seeing at the time. post 2011, and also responsible for unprovoked innocent attacks on bystanders. And in the interim years since David Cameron made this speech, we see a shift. Well, actually, is it a shift? No, it's a continuation of a view of street-based violence. But I would say that there's been a shift in terminology, that there's been a shift in terminology from it being gangs that are most risky towards county lines as being risky. And I'll say a little bit more about that later. And we can see here that Priti Patel, current Home Secretary, is saying in a news report that the government and the police are coming after young people engaged in county lines. This is a drug dealing, a specific form of drug dealing, and that cracking down on these groups would be a priority to the government, and that a lot of money has been putting into tackling county lines, and that as a police force, the police are going to go after the head of the snake when it comes to county lines operations. And it's also within this context, I think I ought to say something about the proportion of crimes that gang members are meant to be responsible for. So according to MOPAC and the Centre for Social Justice, in 2018, gang members were purportedly responsible for half of all knife crime with injury in London. 57% of this was serious and fatal. They were responsible for 60% of all shootings with injury in London, and 30% of all homicides. Now, while these proportions may seem really large, research has shown that gang-related violence constitutes a small proportion of all violent offences. But yet these groups are continuously considered to be the driving force behind some of the most serious violence in the capital, according to MOPAC in 2018. So you can see the framing of serious violence as gang-related, certainly within the criminal justice system and the body politic. But this framing has been of serious violent crime amongst young people as being gang-related has been heavily criticised by academics, including myself, who have argued that it's a tactical ploy initiated by politicians who are under pressure to fix the problem of violence and deflect public attention away from the forms of structural violence, that is poverty, inequality, lack of employment, poor educational attainment, educational exclusion, and systemic and structural racism that is more likely to be associated with the rise in serious violence. Indeed, to deploy a term by Niels Christie, the gang provides a heady, suitable enemy upon which to focus law enforcement initiatives. And as we've seen from research, the suitable enemy in most cases is not white. And you can see from some of the quotes on here that certainly from Horsworth and Young, the term is not neutral. The term gang is not neutral. It's saturated with meaning that is immediately brought into play when mobilised to explain street-based violence by Black or minority young men. Okay, and even though academics have argued the gang is a reified term, and it's still embedded within criminal justice discourse and public policy discourse about violent crime. And it is a term that is frequently used and, according to Smithson, abused when discussing serious violence. And Smithson et al. Have argued that there's almost a symbiotic association made between gangs, drugs, and violence and ethnicity that emerged from the late 80s onwards. And this emergence or merge or association between gangs, drugs, violence, and ethnicity has compounded the view of Black and minority ethnic population as dangerous and as at a particularly high risk for society. Thus, the problem of the gang is a problem of the Jamaican Yardies, the African ghetto boys, the Muslim boys, the Chinese triads, the Turkish Kurdish Baybasin clan, the Asian Fiat Bravo boys, the PYG, the PDC, the rappers, and the drill artists. So that's the kind of cultural and structural context in which detectives are doing their job. So I hope that that gives you a flavour of what's happening in society at the time that the detectives that we spoke to were trying to investigate serious violent crime. So we have some arguments. In my reflections, or our reflections, on the link between the work that the police do and the silence that they encounter in the investigation, I would argue that we need to fully understand how these structural and cultural conditions in which the MPS detectives operate shape their beliefs and actions. Yeah, and how they view silence within the investigative context. And so we have to appreciate the structural and cultural context in which they work. And so we think that that is part of the argument. And to inform our argument, we draw on some theoretical work by Margaret Archer. Now, you'll be pleased to know that I'm not going to go on about Margaret Archer's critical realist perspective because I don't have enough time, but just to say that Margaret Archer's realist perspective, it highlights the importance of the structure and cultural dynamics or conditions on human interaction and reaction. And that's why we suggest that we really need to take account of that when making sense of the work that the police detectives do and making sense of their reflections on the work that they do. And we suggest that the ways in which the detectives see or cultural and structural dynamics shapes their beliefs and actions. In other words, policing practices and perspectives cannot be divorced from the context in which they are situated, because ultimately they're focused quite clearly on getting the job done and convicting people for whom are guilty of serious violent crime. We see the inflation of crime and political demands and the framing of serious youth violence as part of the issue in framing the way the police see their job and how they seek to realise their ultimate concerns. And I'll say something about that in a minute. And we argue that the legal apparatus, that is joint enterprise and the right to silence, helps the police to interpret the silence that occurs in the investigation. And this also has a bearing on how they understand the silence that young people do, and possibly the ethnic disproportionality involved in joint enterprise convictions. So before showing you the evidential basis upon which these claims are made, I need to say something about the sample and our research methods. Susie outlined quite a lot of it, so I'm literally going to trot through. So, yep, we had a cohort of 19 MPS officers. They held various ranks from detective constable to detective sergeant to chief inspector and detective superintendents. They had quite lengthy service in the MPS. All of them had more than 7 years service, and the majority was serving 10 years or more within the MPS. The majority of the officers were white and male, so we and that is probably not a surprise to any of us. And we used semi-structured thematic interviews that lasted anywhere between 1.5 hours to slightly longer, maybe 2 hours. And then in these interviews, we asked questions related to the officers' professional histories, the process of investigating cases of serious group violence involving young people, and their understanding of joint enterprise and the laws related to serious violence. So on with the outcomes. So there's some quotes here by Anne, Detective Inspector, and Louise, Detective Sergeant. And whilst I will leave you to look at those quotes whilst I say something around them. So as previous research suggests, what people are concerned with, what the police officers or the detectives are concerned with is to crack the case. You know, they want to solve the murder. And the detectives in our study reported that their ultimate concerns were justice for the victims and public protection. And you can see this outlined in the quotations or the reflections of Anne and Louise. They wanted to remove the baddies from the streets and provide some sort of justice for the victims. They wanted to get the guns off the streets and stop the stabbings that was happening, you know, stop the serious violent crime that was blighting London. And they wanted to do this by getting everybody who was involved in the case to accept responsibility for the part that they played in the serious violence. And I should say that serious violence, by serious violence, I'm talking about Section 18, Section 20, manslaughter and homicide. But they wanted to ensure that people who were complicit and intended to engage in serious violence were brought to trial and prosecuted fairly, and if the evidence permitted it, to be proven guilty. And when speaking about the serious violence, the detectives constantly referred to gang-related violence. Now, this was really interesting for us because when we were interviewing the detectives, we never spoke about gangs. We never framed the serious violence, talking about serious violence as gang-related violence. This was a term that constantly came up in the interviews, and detectives drew on their experience to in policing serious violence in London as being gang-related violence. And as you can see here, Davidson is saying that this is what they've seen, that they've seen an increase in gang-related violence, and indeed they've seen an increase in some escalation of a, well, let's say, nihilistic mindset of the young people who are engaged in gang-related violence. You know, there's a mindset, a fatalistic and nihilistic mindset that they don't care, according to Davidson, if they kill anyone, or indeed if they're killed, you know, because life for these young people is, according to Davidson, considered cheap. And as a consequence of that, they look to obtain good reputation and credibility and respect, and this is acquired by resorting to extreme violence. And so the detectives in our study wanted to draw our attention to the absolute risk that gangs posed, not only to each other or to people engaged in gang culture, but to other people. As I said, young children, girls, women, other vulnerable people associated with county lines, and wider society. In their reflections on serious violence, the detectives oftentimes equated gangs with black. And in doing so, they drew on racialized tropes that categorized Black young people as gang involved, as risky, as dangerous, and they asserted that the disproportional representation of young Black people in joint enterprise cases is because they were more likely to engage in serious violent crime, particularly gang-related serious violence in London, as victims and perpetrators. And it was this reason that they were disproportionately drawn into joint enterprise cases. So you can see here Patrick saying that there's this whole Black young male thing, that they're seeing young Black male coming through to investigation as victims and suspects. And this is because violence, as Davidson has said, is exclusively the proclivity of urban or Black street culture, where violence is, as Patrick is saying, fashionable. So we need to think about that word, fashionable. I'll say something in a minute. And that there are white guys involved in gangs and knife crime, but it's predominantly a Black man or a Black kid's world. So here you can see the racialized tropes about gang membership and serious violent crime. So we can see here that violence is structured as a Black boy thing, where they are enculturated into a nihilistic, criminogenic and somewhat fashionable Black street culture. And I think this is reminiscent of the statements of statements about ASBOs being fashionable or carrying knives as being fashionable. Now, we can't say for certain that Black young men in London are more likely to be involved in serious violent crime as perpetrators, because the data is poor. It is really poor, and there is research that challenges the construction of violence as gang-related violence, or indeed as young Black men being the majority perpetrators in serious violent crime. Needless to say that the detectives that we spoke to that were investigating serious violent crime suggested more often than not that it involved Black and mixed race young men disproportionately, and they were coming into the police station to answer cases in disproportionate rates. So you might be thinking, what does this have to do with silence and the legal trap? Well, as Archer notes, structure and culture within the world in which the detectives operate and that they try to do a good job impacts on the way in which they interact and interpret the actions and behaviours of their suspects and the witnesses that they engage during a case involving serious violent crime. So I hope you can see from the previous slides that detectives consciously or unconsciously are reflecting and filtering the actions of suspects and witnesses, and they're judging this against their own set of criteria or judgments, and viewing certain people, black people, black suspects negatively, and certainly within the context of the gang. What I'd like to say is that, and Susie outlined this before, and I'm sure most of you know, that within the context of the investigation, there is a right to silence. And as Susie noted in her presentation, the accused doesn't have to prove that he, she, or they did or did not do the crime. Indeed, my understanding is that they don't have to say anything, that it is the duty of the prosecution to prove the case against the accused, and the suspect is not compelled to assist in this case. And Susie spoke about the changes in the right to silence law, and you can see those changes on here. So I'm not going to labour that at all, but just to say that the changes in the rights to silence has altered the inferences that can be drawn from the silence that suspects and witnesses do. And these adverse inferences play out in the investigation. And an individual of black or mixed race boys that are exercising their right to silence within the investigation situation, their rights to silence can be interpreted as foul play, since in Susie's presentation, it's common sense that if you were innocent, you'd say so within the investigation, and any silence could or is interpreted or associated with culpability and guilt. So this is where I think it starts to link with silence. So here is an example of the adverse power of silence. So irrespective of the reason why Raj stayed silent, he did so, and he did so because his solicitor told him to go no comment in the interview. He was a young man at the point of investigation. He was only 19, and he had very little legal knowledge. He'd never been in a murder case before. He was bamboozled by the evidence, and he didn't know what was going on, in his own words here. And so he followed his solicitor's advice to go no comment. And so in the police station, that's what he did. He went no comment. And then when he went to court, they said, well, you could have made your own decision. And he said, well, yes, I could have, but I was 19 and I was doing what I was told. So there were certain inferences, adverse inferences that were made because of his silence and because of his right to exercise silence within the investigative process. So what Susie alluded to in her presentation is that some suspects, they do speak, and not everybody remains silent. But what happens when people break their right to silence? And they start to speak within the investigation. They speak to the police. So you can see here two quotes, one from Kevin, one from Michael, on the implications of speaking within the investigation. So they did talk. Kevin said was asked by the police to come in for a witness, and he said, okay, I'll tell the truth. They'd found his top, and he said, yeah, look, I was at the party, but I wasn't involved in the attack, and nor did I assault anyone. And they said, well, I'm sorry, but we're going to arrest you for blah, blah, blah. And as Michael says here, I told the truth and I still got convicted. So Kevin and Michael's testimony is somewhat discredited, perhaps, by the stereotypes and associated prejudices that underpin what people, or particularly young Black people, say in the investigation. I think you can see here that the information that they imparted in the investigation is somewhat devalued, because devalued by the detectives in this case. They had told the truth, they had given their truth, and it was dismissed within the investigative situation. And so this is kind of problematic, because if suspects stay silent, then there are adverse inferences, but yet if they speak, there are adverse consequences. So we don't know categorically whether no comment interviews, i.e. to remain silent, is correlated to ethnicity. And there doesn't appear to be any research on this. And if anybody listening does know of any statistics in this area, we'd be really pleased to see them. But what we do know from a plethora of research is that there is a lack of trust within minoritized communities about the police, and a reluctance to engage or cooperate in police investigations. What we also know is several things about disproportionality in joint enterprise cases, and you can see these reported starkly here. We also know, according to the Lamy report, that Black defendants are more likely to plead not guilty, pushing their case towards the Crown and a trial by jury. Perhaps this is why some BME, Black and minority ethnic young people, take the risk and go to court rather than speak to police in the interview. As one young man, Omar, who was incarcerated for Section 18, says, the police, they twist your words at the police station. You say that you went to this place and how long you were there for. I can say how long I was there for, but they try to twist your words. So my concluding thoughts are these. Just to say that the act of violence is a serious one and it should not be taken lightly. Serious violent crime has a significant impact upon the victims and their family and their wider community, not to mention the perpetrators known by them. The detectives interviewed for this study, as agents of the law, took their role to investigate serious violent crime very seriously. The detectives that engaged in our study were focused on their ultimate concerns. And if you remember that these were justice for the victim and to protect and serve the general public, but we can also say that their concerns was to reduce violent crime in London. They wanted to catch the perpetrators, they wanted to catch the bad guys, and arguably this is what the police should be doing. People are dying and they were trying to do a good job in those circumstances. The structure and culture had a significant influence on how detectives reflected upon the rising rates of violence and how they investigated serious violent crime. And they had the legal apparatus to help them to achieve these ultimate concerns. However, at the same time, we can see from the findings that the ways in which perhaps the detectives are constructing the narrative about serious violent crime in London, ultimately that it's based on the violence that young Black people do and their adherence to a pathological gang culture, is racialized. and they're characterized as being risky and dangerous to the general public. And so it's into this context that a disproportionate number of Black young men find themselves in the police. And it's into this context that young Black and mixed race men try to exercise their right to silence. And it's in this context that their silence is viewed suspiciously, in some ways suspiciously by detectives. In many ways, the investigative context puts Black and minority young men in a compromised, if not impossible, position. To speak risks possible charge and conviction, particularly if their truth isn't given any credit. To stay silent risks the adverse inferences. I'm finishing. I've got one little sentence to say, Felicity.
Come on. It wasn't me. I think someone else has got their keep going. You keep going. I think someone else has unmuted themselves.
Okay, so I'll just rewind. So it's an impossible position. To speak risks charge and conviction. To stay silent risks adverse inferences drawn from it. So here lies the trap that young Black and mixed race young men disproportionately find themselves in. Now, if we add these to our findings to other research that shows young Black people are less likely to be afforded the privilege of innocence within a police setting and are more likely to be seen as older and less innocent than their non-Black peers by peers and the criminal justice system, that, as Goff et al. Tells us, and as we find from Skins et al.'s recent research on dignity in the police, in police custody and detention, that suggests that Black and BME young people are less likely than others to feel like they are treated as a person of equal worth or with dignity in police custody. Then we can see how, within the context of the investigation, they don't speak. And if we add this to detectives' need to reduce violent crime and to get justice for their victims and fulfill their ultimate concerns, we may be able to see how this impacts disproportionately on Black suspects and witnesses, that leads to disproportionate joint enterprise convictions for them. And that's me finished.
Fantastic. Thank you, Tara. A really fascinating insight into the structure and culture of the criminal justice system and the issues that arise in these types of cases. And we've been going for about an hour and a quarter. Thank you very much for everyone who's stayed. I am going to keep going. I think I'd like to finish off this webinar with some of the observations that I want to make, and deliberately to remind you that what I'm going to tell you now is anecdotal. It's not academic research. I thought it's quite interesting to be able to give you some examples of recent cases within the last year in England and Wales that I've done that have given rise to these issues. And just to give you a background, without giving you a lecture on the case of Jogi that I led in the UK Supreme Court, it's worth remembering that we argued the principle of legality. We said it wasn't clear to the public where the law on accessories or secondary liability in complicity, which was known as joint enterprise, it wasn't clear where that law began and ended. So the public didn't understand at what point they would be held liable for the offence for which the serious offences for which people are charged. And that argument that we put forward didn't make it into the written decision of the court. They didn't address it at all. Similarly, one of the grounds of appeal was that joint enterprise over-criminalises secondary parties. And again, the UK Supreme Court didn't address the grounds of appeal. They gave a decision but unfortunately, without giving those explanations, they didn't answer the questions some of the questions that we'd invited them to answer. And they're also not clear on causation, which is one of the issues that's arisen is arising more and more, that it's not clear what connection someone has to have to a crime before they can be accused of that crime. And at the moment, the approach of the Court of Appeal, certainly in the recent case of Grant, seems to be that there doesn't have to be a causative effect on the crime itself. So you can assist or encourage, and it doesn't necessarily have to, in fact, assist or encourage. So there are real problems on the explanation in Jogee as to how the law operates and what's meant by a nexus or a connection to the offence, and when is the activity too remote to be considered an overwhelming supervening act. So we'll have another webinar on joint enterprise or complicity and causation later on in our series of webinars. But I think it's worth thinking about all of those issues that haven't been answered by the case of Jogee. And it might well drive us to thinking about why it is that we don't have more cases where alternatives are used. So the charge is not murder or manslaughter, but affray and violent disorder that may more properly reflect the behaviour of a particular person in a crowded incident. And why there isn't greater use of diversion, even where someone has died, when it's a group incident or lots of people are present. What's the problem in enabling diversion of young people, which may well enable greater conversation with those young people as to how things came about, and acceptance that what those young people are saying is true, so that they're diverted or charged with alternatives and not charged with murder or manslaughter. So those are just some overview thoughts, but these are the cases that I wanted to tell you about, and they are all within the last year. In one of the cases, I defended a 13-year-old child who, just bear with me a second, my screen seems to have frozen. Am I still here?
Yes, you are, Felicity.
Oh, lovely. Thank you. I can't see my own notes at the moment. I do apologise. Thank you for telling me I'm still with you. Here we go. So one of the cases I represented a 13-year-old autistic child. He was white, but from a low socioeconomic economic group. There was a background of drugs that was labelled on and off county lines. What we did in that case was my junior and I presented the Hulley and Young research on silence to give the court, give the judge the academic research. And I have to say, I do this quite often. And I've had one judge who simply refused to read it, and other judges who've been really engaged and interested in the research. And I do that in various different ways in the context of joint enterprise. But here we particularly used the research on silence to try and persuade the court that this was a vulnerable child that the court could accept would find a police interview extremely difficult. We had evidence that that child had difficulties with processing and responding to information, including faces, body language, and social sciences, and evidence that that client would suffer heightened levels of anxiety, likely to affect both communication and memory. So we were able to provide both the academic research generally and specific evidence, expert evidence in relation to this particular child. And we submitted that it was crucial that measures were taken to adapt the process to accommodate that client's individual needs to allow them to effectively participate, and that the adaptations in the police interview were not sufficient. So there were two drivers, really. The broader drivers that cause a young person in that situation to remain silent, but the specific drivers were the failure to adapt the process for the interview. Save for having an appropriate adult present, it's still a really at least stressful situation for an autistic child to be in. So that's a disabled child with a diagnosed disorder. who was interviewed without being assessed for either of those conditions, only assessed after charge when there was funding for the defence to obtain that expert evidence, interviewed without the presence of a known social worker, someone that knows that child, or an intermediary to assist that child to effectively participate in the process, even though that child had an intermediary at trial. So we argued that the child had a right not to answer police questions, that the child had exercised that right on the advice of the solicitor. And given the child's age and disabilities, that was the correct thing for the child to choose in those circumstances. So we accepted that the police had recognised their duties under codes C and E of the Police and Criminal Evidence Act, which extends to mental vulnerability, by providing an appropriate adult and offering breaks to discuss matters with the solicitors, as well as contacting a social worker. However, we said that those arrangements simply were not sufficient adjustments. Firstly, to enable effective participation by someone with those diagnosed conditions, but also to demonstrate that it was inevitable that the client would follow the solicitor's advice. It was inevitable the client in those circumstances would remain silent. And there was evidence that the child had demonstrably had issues with engaging with the process. The police officer during the course of interview had said the client needed help, had an inability to recollect the caution. The child was obviously dependent on the solicitor during the course of the taped interview. The child was regularly encouraged to defer to the solicitor's views by the interviewing officers. Have a break, go and speak to your solicitor. So the child did speak to the solicitor and consequently was silent, and that had a determination in the response to the questions we suggested. The result was that the client answered no comment to most of the questions that were put in the police interview. And we said that actually that evidence shouldn't be placed before the jury at all, at least not without some qualification. So what we did was make an application to exclude the no comment interview, and suggested the way in which we could formulate words to deal with that. But essentially, short version is that although the appropriate adult was useful, the dominant strategy inevitably was that the client would remain silent, and that therefore the use of a no comment interview in many ways was harmful if it was used in a trial. Ultimately, neither a solicitor nor an appropriate adult is a replacement for a proper psychiatric or psychological assessment, none of which was done before the interview. No assessment as to whether that child needed an intermediary. The result was that the judge excluded that no comment interview. And we accepted that there might be some need to explain this to the jury, but we carried on with the trial. So I think perhaps to the surprise of the prosecution, it was a High Court judge who said, no, the jury were not going to be told about any interview relating to that child. However, the child then did not give evidence at trial. And we had quite a significant exercise here. We had to seek input from experts as to whether or not that child was making a free and fully informed decision. We were unable to say that this was not the client's own choice not to give evidence at trial. I have to say, in those types of cases, you tend to have a suspicion that the child has been influenced in some way by those persons with whom they're sitting in the dock. And this was a case where we'd asked for the child to be out of the dock, but the judge had refused. And I can't say that that was the result, but it was a real worry as to why this child chose not to give evidence in the trial. And even against that background, an adverse inference direction was given. So despite excluding the no comment interview on the basis that that child should not have been interviewed in the way that he was and the dominant strategy was silent, the judge then gave an adverse inference direction in the trial for not giving evidence at trial. And it was a case where the court also ruled that the jury were not to be told that that child was autistic. So that's the sort of issues that arise in relation to disabled children that give rise to serious concerns, as far as I'm concerned, as to whether or not there has been procedural fairness in relation to the approach to children in police stations and how that affects the future trial. Another case where I represented a Black teenager who was 17 at the time of the offence and 19 at the time of the trial. That client chose to give evidence. And it was in a case where the prosecution, one of the charges was joint possession of a gun. And another person had the gun. Another person was seen on CCTV with the gun. There was an issue over whether it was a gun at all, but they were certainly holding something. And our client was no more than present and running around at the point of an incident between a car and the co-accused who was carrying this implement. And the prosecution used that language of driving force that we've heard from Tara, this rhetorical language that's used in trials, to try and infer that somehow he was in control or joint possession of that gun. So I thought he was pretty brave to give evidence against that background, that sort of language that the prosecution used that we've heard of in this presentation. The other charge involved a conspiracy to murder, where the evidence was that the client had gone into a building where a drive-by shooting was planned, but there was no evidence of him ever coming out of the building. And yet the prosecution suggested that simply going to that building against the background of his association with other people in the locality, the gang narrative, meant that he was part of that conspiracy by going to that building. Prosecution also alleged that he was involved in gang-related activity because he had a nickname on his PS4 gaming system, despite information that we were able to provide that nickname was referred to in over 70,000 songs, and that a PS4 handle is not necessarily a name that a person would use in ordinary circumstances. People pick all sorts of names for their technology. It isn't necessarily the name that they would use amongst friends. And yet it was constantly referred to in the trial as some sort of nickname. There were these really old-fashioned approaches to music and associations between young people. Fortunately, when the prosecution sought to rely on some music lyrics, that was excluded properly, in my view, by the judge. But the judge didn't accede to a submission of no case to answer. And I think there's some real work to be done on which cases to stop. I think this was a case where it should not have gone beyond a submission of no case to answer. So again, I think it was particularly brave of the client to give evidence in those circumstances. And we did have a situation where the cross-examination involved not accepting any of the truth that this client was giving when giving evidence. It was accepted by the jury, and the jury was very diverse. But in closing the case, the prosecution gave a speech which included the phrase, "These people are not normal," to which, of course, we vociferously responded in our speech. But it was a really uncomfortable trial to be in. And the prosecution left their case to the jury on a different basis and a speculative basis in their closing speech than they had suggested throughout the trial. And I raised the rule in Brown and Dunn that really they should not be allowed to rely on that speculative basis. And the judge had to make sure that the directions ensured that those speculative assumptions by the prosecution were not engaged in by the jury. And the judge did direct the jury rather perhaps more fairly than they do in some cases. So it's a really interesting dynamic, and one in which the client was, in my view, properly acquitted when, in fact, a submission of no case to answer should have been successful. But a very, very, very difficult decision for that client to make, to physically go into the witness box and be cross-examined over what I think was 2 days at the age of 19 about something 2 years earlier that involved some really problematic and personal circumstances for him, and to be examined really about everything in relation to his life, including his use of his PS4. Another case that I did was a Black client who was, I think, in his 30s. He remained silent, and in that case, others gave evidence. And again, it was a case where the client was alleged to be a drop-off driver for a drug deal. Now, judge quite properly excluded gang allegations because the prosecution didn't put their case that this was a county lines gang coming to take over in the area. They simply said it was an incident that happened outside a car when the driver was dropping them off for a drug deal gone wrong or for some sort of attack. And the jury were left to pick the bones out of whatever that argument was. In my view, there was never a way of for the prosecutor to show this was not an overwhelming supervening act. And I think that's the basis on which the client was acquitted. But what was really interesting in that case was that the witness to the main events was a child who had an intermediary. We used all the toolkits and the tools, including toy cars, as to where the vehicles had moved to. And the child agreed that the police reconstruction of the events was wrong. So the witness had not been interviewed in a way that was helpful. So there were some assumptions of guilt and some assumptions about the case that led to very poor interviewing of the child witness, never mind a child suspect. And again, this was a case where an adverse inference direction was given, but you start to ask, well, why? What impression does that give when you've got very limited evidence, if any at all, against a particular client? Is it the adverse inference legislation that is getting these cases over the line or not? Some people in that trial were convicted, others were acquitted. Is it the adverse inference direction that is actually making a difference for weak cases being the subject of conviction? There were mixed verdicts in that case. It didn't make that difference in relation to our client. But most importantly, as a sort of learning exercise, if there is one here, what our speech was, there is no case to answer. And if there's no case, you can't draw an adverse inference. And we had to sort of ram that home. And it seemed such a shame that we had to make that much clearer than it was by the prosecution. The last case I want to tell you about very quickly, and I'm very pleased that so many of you have stayed for so long, it's such an interesting subject, was an Asian teen who was 19 and was convicted after a trial of murder. He was never at the scene. He was in the car outside. His case was that he was waiting for others to go and steal some cannabis. That theft went wrong, let's put it that way. And tragically, someone was stabbed to death. And he cooperated in his interview, was silent at trial. It was an all-white jury. Lawyers in the case who were Asian were subjected to street insults by passing vehicles on their ethnicity. That was the context in which this trial was being held. The prosecution evidence against one of the defendants in that case was solely based on a pattern of telephone calls. So although that defendant gave an explanation of what his calls were about, the prosecution case was based on, well, that pattern of telephone calls means you were involved in the event, without having the content of those calls, just when those calls were made, which inevitably invites stereotypical assumptions. So it's a very high octane trial. Our client in the car, not at the scene. And the prosecution case was based on a presumption that he'd seen the knife because it was big. There was no evidence that he'd seen the knife or knew that those people were taking a knife to the premises. He was present at a car park afterwards where cleanup took place, but he went off in another vehicle and didn't participate in that cleanup. But then the prosecution used his extended presence to draw a wide inference that presence was sufficiently long to amount to participation. So again, if you unpack that for a moment, extended presence at a scene of an Asian person is somehow an inference that that person is involving themselves in what other people are doing, which is a serious concern in my view, in the way in which cases are both being presented and left to a jury. And in nearly all of those cases, the judge gave the lookout example without agreeing with me that lookout example is wrong. They do it in nearly every case involving multiple defendants. They say, well, look, if someone's a lookout at a burglary, they are equally complicit. They are a secondary party. But the problem is that doesn't really explain that being present outside a property doesn't mean that you're necessarily complicit in what's going on inside that property. That was exactly the point in Mr. Jogi's appeal. It's only if your conduct is such that it demonstrates an intention to assist or encourage. So you could be outside a building, or even in a car away from a building, some 200 or 300 yards away from that building, and you're not a lookout because you're not in a position to be a lookout. And yet you can still be convicted of being complicit in someone else's crime, as these example cases suggest. And in several of these cases, I've sort of suggested it's almost like the Victorian dad approach, isn't it? You know, you shouldn't have been there and therefore you must be guilty, which is an objective test, and the law is meant to be subjective. So it seems to me, at least, these extended inferences that we have, plus these adverse inferences as to silence, have moved us back towards some sort of objective assessment of whether someone is guilty that brings in all those stereotypes and tropes, and therefore is leading to significantly unsafe verdicts in a range of trials that actually, for young people, probably should lead to alternative charges and diversion. And those cases that I've done recently, although obviously I've told you that I had some success in some of them, not in all of them, and they were all cases where I took the view that there could have been a different approach, both procedurally and substantively, in those trials. Separately, as some of you know, I am an academic as well as a practicing academic, I suppose, and I've published a game theory paper that tends to demonstrate that the pressure on people in the criminal justice system to plead guilty, to admit some sort of crime that they don't necessarily understand the law on, creates a dominant strategy of silence. So there is a dysfunction in the system itself, that this constant drive for guilty pleas, admissions, confessions, that is then assessed by the police and prosecutors, creates that dominant strategy of silence that we've heard from Susie and Tara today. So I think it's also mathematically proven through what's known as the prisoner's dilemma. So look, I'm really grateful that you've all come to this webinar. I've got a couple of questions for Susie and Tara myself, but if you have got any questions, feel free to put your hands up or put it in the chat. I think we're really thinking here about the structural and cultural context in which we work in the criminal justice system. And as an anecdotal story, in the last 6 murder trials that I've done in England and Wales, there were 49 professionals, that's lawyers and judges. Out of those 49, 3 were women and 3 were people of colour. The overwhelming percentage was old white men in some sort of war on an alternative culture that they didn't understand. It was extraordinarily adversarial, and yet it nearly always involved children and young people, which it seems to me we can't divorce this privileged profession that we work in from the outcomes that are occurring, the attitudes to silence, the interpretation of silence, the understanding of silence, and the manipulation of adverse inference directions. So those are my anecdotal thoughts and obvious opinion that I at least think are reflected in the work that Susie and Tara, Dr. Young and Dr. Hulley have done. I'm just looking to see, for those of you who've managed to stay for 2 hours, whether there are any questions. There's a couple. Susie and Tara, I don't know whether we're able to see you for the last couple of minutes of this session.
Just trying to put my video on, but I can't.
That's
see
okay,
me.
but if
You can.
yeah, it just so that gives you a chance to answer visually as well. But question 1 is, should we reverse the legislation and repeal Section 34 of the Criminal Justice and Public Order Act 1994 and its related provisions? It's a loaded question, of course, but is it time to repeal the adverse inferences from silence laws? What's your view? Mine is yes, for what it's worth.
Yes, I mean, I think I said at the end that I think that's something that certainly needs to be considered. And it seems to me, I mean, certainly listening to your cases, Felicity, which is always so interesting to hear about that 13-year-old boy, the thought that his silence could be considered as an inference of guilt rather than all these other things that might reflect, seems ludicrous to me. I would probably, because I'm a criminologist, push it back to the lawyers to make it to tell me how, like, what the best way for that to be done is. But yeah, I certainly think that given the concerns that we have about it, something serious and significant needs to happen.
Tara?
Yeah, I'm in agreement there. I mean, given the cultural and structural contexts and the kind of the racialized narratives that sort of populate the criminal justice system, I think that it would be, I'm not a lawyer, so I think it would be wise to maybe have another look at the adverse inferences and how that some way adds to the prosecution of young people, particularly vulnerable young people, like the 13-year-old you were talking of in the case that you've just done. So yes, I think is the answer from me.
They're really shocking cases to be involved in, and for me it sort of blows my mind because I've also read the research and I'm often in a room with people who haven't read the research, so I think it sort of feels very, very hard for me, and I almost take it personally. So they're exhausting cases as well for the lawyers. But look, we've got a lot of lawyers in the room, so I think we should be thinking about this type of reform and listening to the criminological research to understand whether or not the reaction to the Macpherson report back in 1993 was wrong, and that the implementation of the adverse inference directions is now understood to be wrong. So how many years are we? 94, 2004, 14. We're nearly 30 years on. Jogi, the courts took 30 years to recognise, at least 30 years to recognise that the law on secondary parties had gone wrong. So here's an opportunity to recognise we've tried something, the adverse inference system has gone wrong too, and it's time for reform. Final question then, for the policymakers in the room, for both of you, should we reform charging policy? For, again, very loaded question, but for greater use of alternatives or diversion for those who are on the periphery, which is a loaded phrase in itself, but not necessarily the principal offender, or indeed their levels of assistance or encouragement are very low. And if we should reform policy, sure, which would be your first approach? I suppose it's like, well, where would you start? And I know that could take us another 2 hours to discuss, but my view is a greater emphasis on diversion and alternatives for young people, so that we don't criminalise young people who are plainly, like the example I've given you of the gun, not in control of the events around them. Or even if there is some concern about control, it's a good time to capture that person to try and divert them to a different path. What do we think about that? I think that's probably a very broad question, so I'll let you pick up whichever bit you like. Thank you. I'll go to Tara first this time.
So I think that within the context of my presentation, I just think that there should be some sort of critical reflection of police officers when they come to their charging decisions, and to take note of the ways in which they are creating the conditions within the investigative context. And within that, I would suggest that that the decision to charge follows the evidence, that if the evidence is super flimsy, then there should be a less of a reluctance, a less of a move to charge, and rather a move to diversion, so that young people on the periphery, or those who are with very minimal involvement in the case, in the crime, get filtered out more quickly than they are at the moment, and don't find themselves in front of a jury. I hope that's kind of not too fluffy for you.
Thank you. Yeah, I think, you know, within a courtroom, we have different views on what minimal means and flimsy means and so forth. But I think you're right, it needs a further conversation. So I think that gives you the last word, Susie. So
thank you.
Any last reflections on that enormous question?
Yeah, I think one thing it made me think is that when we did some previous research that we did on people who are convicted of murder from a young age, the people who are convicted of joint enterprise as secondary parties almost always said they should have been convicted of something, you know, or if they felt that they were involved at all, they recognized, you know, perverting the course of justice or something like that. And it wasn't only that they thought that this was an entire miscarriage of justice, it was the fact that they were convicted of murder that was the thing that was the most the hardest to understand, because that they didn't identify themselves as having committed a killing. So I think the looking at alternative charges, you know, that's all people who are convicted are asking for often. You know, there are people who absolutely weren't, you know, say that they weren't involved at all, but for those people who recognize that they had some sort of peripheral involvement, they're just saying, well, yeah, but just don't convict me of that. I have to apologize if there's background noise of my children going in the bath. Anyway,
I like it when they're junior, and we've obviously been going on for too long. But
one other thing I'd say is just that I think a lot of the issues as well are the assumptions that are made, which is what Tara's been talking about. And also drawing attention to the assumptions that are made about women. And so about whether somebody is assisting and encouraging often is based on assumptions about their riskiness if they're Black. You know, they almost certainly must have been encouraging because, you know, that, you know, what those people are like when they all get together and they all have weapons, but also with women as well. You know, women who are who are secondary parties to offences that are committed by men who have been coercively controlling and domestically violent to them, and then the assumptions about who those women are and what they assisted and encouraged, when actually there were all these other dynamics around coercion and violence. So I think certainly reform and changes in practice that are kind of rooted in, like you said, these sort of normative white male rational assumptions about who people are and what they are capable of. I think a lot of those things need to be challenged a lot.
Thank you. You've neatly led me to our next webinar, which is going to be on maternal filicide on the 28th of October. So without knowing, you neatly allowed me to say that we're going to be talking about women and assumptions about women in the context of maternal filicide on the 28th of October, and that will be advertised very soon. I think that's all the questions that we have. So thank you everyone for staying for so long.
Yeah,
as ever, we've rattled on for over an hour and a half. My sessions always do. So I'm really grateful, including to everybody's children who are watching from the bath, as it sounds like. But to all of those of you with children with domestic responsibilities, dogs and goodness knows what else. Very good of you to stay for so long. We will follow up this with an article that goes into Libertas Lens, so you will get to see the slides and some of the things that we've talked about, and we combine our notes into an article. You'll see some of the previous webinars have been written up as articles in Libertas Lens as well, and eventually we will put out this recording in an edited way so that will be available to you all. If you don't have academic access to the papers that we've referred to, we will make sure that there's links and citations to those papers in those articles so that you can find them and hopefully get access to them, and if not, request from us access for the purposes of your case. I think we're allowed to share academic material for limited purposes outside of the paid for databases, so I'm sure we can facilitate that too. Thank you so much to Dr. Hulley and Dr. Young for presenting their research. It provides us with a foundation to reconsider policy and charging policy, and indeed the effectiveness of legislation, and whether in fact we should be reforming some of the laws that came in nearly 30 years ago as a result of the Macpherson report that may have actually done more harm than good. So I'd like to say thank you also to Gary, somewhere in the background, one of our clerks who stayed for a couple of hours to make sure that we all stick together to hear this. And very grateful for you all attending in such high numbers, and look forward to seeing you next month. Thank you very much.
Thanks, Felicity. Thanks,
everyone. Thank you, Tara. Bye-bye.
Bye.